Welcome. This is the Family Law Channel. I'm Scott Drake with my guest and the beloved host of FLC, retired California Superior Court Judge Eugene Hyman. How's it going in Santa Clara there, Judge Hyman?
It's a beautiful day when every day is Saturday.
Spoken like a true retiree. Here we go. The U.S. Supreme Court recently revisited as you say, the heavily disputed territory of civil Gideon, which is the doctrine delineating when, if ever, indigent civil litigants are legally entitled to counsel appointed and paid for by the state. Judge Hyman, so explain again to those watching here what civil Gideon is all about and why are they back at it?
Sure. Basically, the premise is that has something raised to a high enough level where constitutionally a person is required to have counsel represent them if they are indigent or otherwise unable to provide their own counsel. Examples of this might be in certain kinds of family law situations where, especially if child custody, visitation, access cases are involved, or perhaps in child support or maybe even spousal support, where one side has counsel but is unable to provide or be required to provide counsel for the other person, and has an inequity been reached to such a level that fairness requires that there be an attorney appointed to represent that person. There's also situations where a person potentially might face contempt. In other words, let's say that you're not paying your spousal support or your child support, but yet you don't have counsel to be able to explain in a adequate fashion to the court why you're unable to do so. You therefore might be actually in contempt. In many states, if you are in fact potentially facing jail time for the contempt, you are entitled to counsel. But that would be if it were a willful failure to pay. If it's not willful, then you probably are not in a situation where you're potentially facing incarceration. But still, you potentially might face some kind of a serious enough consequence that the Supreme Court's going to say that you have to be provided with counsel. I'm of the viewpoint that children are better served when their parents have lawyers or when the children have lawyers. Having said that, obviously this is a very expensive proposition, and the United States is one of the unusual places where legal aid does not come in to play in terms of representation in a family court situation. In Canada, for example, if you qualify, there will be some type of representation involving certain kinds of family law issues. I'm not saying that the person's going to get the Cadillac program or that they're going to get representation for everything, but certainly with respect to child visitation and access, they will be able to get some kind of assistance. That's not true basically in the United States. Under California law, if a judge decides that a child needs an attorney because of the serious discord with respect to the parents and their litigation, then the court will appoint an attorney for the child, but that usually comes out of the court's budget. And especially given these very serious economic times, obviously courts don't have a great deal of discretionary income to be used for this purpose, and as a result, there's been a decrease with respect to the appointment of attorneys for children. I certainly can appreciate that a lot of listeners might feel that this is grossly unfair, that they may, through taxes, may have to fund attorneys for this purpose. But the other potential outcome, if there isn't representation, is that children wind up in a precarious situation with respect to visitation, custody, or access, and the end result is that they become wards of the, or dependents rather, of the state, or that they somehow get hurt, in which case then the expenditure that we'll be providing for, whether it be for medical care or legal costs down the road, would be a great deal more therefore it makes more sense to try and do something about it with respect to the front end.
And to clarify this, the High Court ruling here on Turner v. Rogers, this was regarding Michael Turner, who was a deadbeat dad with a drug problem, and they vacated the lower court ruling because they had determined that this was civil litigation and not criminal, which is where civil Gideon, for some reason,
Right.
pertains to only, right?
Yes, and California actually, Governor Schwarzenegger, before he left, did sign in California a civil Gideon bill, but my recollection is that there is a funding issue for it, and given California's serious economy difficulties, I don't expect that that's going to be provided for in the state budget for many years to come.
Mm-hmm. Given the closeness of the High Court ruling, it doesn't sound like this is over.
No. This is something that's going to be revisited because now, as a result of the recent Supreme Court case, then the states are going to have to make an effort to apply that decision with respect to their own legislation and their own case law. And these things have a tendency to bounce around for years. Unfortunately, one of, I believe, the shortcomings of our court system, whether it be state or federal, is that they don't give advisory opinions, and the other thing is that courts only address the specific narrow issue that is presented to them. They do not, as a general rule, anticipate problems coming down the pike. Usually what they say is that these issues will remain for another day when it's basically squarely presented to them, which does, I think, a disservice to us, but that's what they have always done.
And I guess in closing here, the general problem we have now with economics being one of them is that the public defender's office in most states is overtaxed in a lot of ways.
Absolutely.
And so these people aren't going to get good representation anyway.
Correct. Number one. And number two, by and large, with respect to public lawyers, they're usually specialists with respect to criminal law. It would be an unusual situation that you'd have lawyers out there that are working for a governmental entity that are experts at all in family law or any of the derivatives. The closest thing probably where there is representation is in dependency court, which is abuse and neglect, where representation is mandated by both state as well as federal case law, where parents are provided with attorneys because we're talking about potentially taking children away and maybe even termination of parental rights, which is such a serious potential consequence that the law mandates that they must have counsel. And that's a very expensive, obviously, proposition for any political subdivision to provide those attorneys. But courts have said for years that when a person's potentially losing their children, whether it be temporarily or permanently, they're entitled to representation.
Judge Hyman, thank you.
Thank you.
He is a retired Superior Court judge in California, Eugene Hyman, and you are watching and enjoying, I hope, the Family Law Channel here on the Legal Broadcast Network.